We now call the third case on this morning's docket. That is case number 112806, State of Kansas versus Jimmy Jermel Netherland.
Please, the court. Gerald E. Wells for the appellant in this case, Mr. Netherland. Chief Justice, I would ask for 3 minutes rebuttal, please.
3 minutes is granted, and counsel, as I've asked other counsel in the preceding cases, if you could take maybe 60 seconds to give the people watching on their computers an overview of the facts of this case, that would be appreciated.
The facts of this case is that Mr. Netherland was charged with a number of counts of criminal activity, the most important, the most serious of which is either felony murder or first-degree murder. This was a obviously serious case. There were a number of moving parts in terms of witnesses, a number of defendants in the case. And this particular issue on appeal comes on regarding statements that were made in rebuttal on closing by the prosecutor in the case, called prosecutorial misconduct. And in a very unusual way, it is rare in my experience that you have one statement that is so egregious that it raises the real specter of prosecutorial misconduct. But that's exactly what happened in this case. To put it further in perspective, there were a number of letters that were introduced into evidence by the state that allegedly were wrote by the defendant, one of the defendants, Jimmy Netherland, my client. And these letters were important, if not really significant, because the evidence, as it turns out, was tenuous from the standpoint that there was very little scientific evidence to link Mr. Netherland with this crime. There was no confession. They didn't find the gun, and they had to go about it, the state, in a very convoluted way to present sufficient evidence, in my view, of his conviction. In any event, comes the closing argument, and the prosecutor on rebuttal in closings makes the following statement. Now, folks, if for a minute you believe the state somehow contrived the letter or letters as suggested, well, you have to acquit the defendant. That is a clear and obvious personal comment on the evidence by the prosecutor, which the prosecutor cannot do under our law. Now, to put that in perspective,
how is that a personal comment when he's talking about, I mean, he uses the pronouns you. I mean, he's not saying I or anything even similar to I think. Well, how is it a personal comment?
I'm sorry. Well, it's a directive to the jury that it's his opinion that if they believe this, then they should acquit the defendant.
Wasn't that the defendant's argument?
Well, no. It was said in a very, no one believed. Certainly the defendant did not believe that that's what he meant. He wasn't standing up there saying, you have to acquit this person. It was a personal comment on the evidence, and I think it's important to put it in perspective as well. And that is, prosecutor is reacting to comments made by defense counsel about these letters in closing. And as she should have, she comments that their own expert could not connect these letters conclusively to the defendant, Mr. Netherland. She argued that the chain of evidence was weak and tenuous. She said that there was, well, in fact, she never used the word contrived. That was his word. That was the prosecutor's word. It was a personal comment, and where he was trying to lead the jury was to convict this man, Mr. Netherland. That was not what he intended. The very statement alone is, if not sarcastic, is dripping with sarcasm.
Well, counsel, the trial judge heard that argument and said the tone was not inappropriate. Did she not?
She did. We disagree with the judge's ruling in that regard.
Well, she was present to watch the demeanor of Mr. Biggs, the prosecutor, and hear the intonation in his words. Is that right?
Correct.
And you and I were not.
No, we were not. I understand the court's point, but we just disagreed that this was not a clear statement of a personal comment on the evidence. And it was a deliberate comment on his part. If he wanted to leave personal comment out of it, there were a number of ways he could have approached the evidence in terms of the letters that were admitted. Because, again, defense counsel brought up all of the negatives regarding the admission of the letters and why Mr. Netherland possibly did not pen those letters. And he took it upon himself to insert a personal comment regarding the evidence. Now, I understand the contrary argument, which is that he was reacting to suggestions by the defense counsel, but he could have done it in a non-personal way.
I'm sorry, I'm repeating myself here, but
I
that's
understand.
because I've heard you say personal comment multiple times. Maybe I'm just disconnecting, but can you specifically articulate how this was a personal comment made by the prosecutor?
Yes. First of all, it wasn't in the instructions. There was no instruction that he was commenting on. What he said was, you have to acquit the defendant if you believe that these letters were contrived.
And so what is the prosecutor's personal opinion? I mean, where
You
is it
have to-
contained in his statement?
You have to acquit the defendant. He's not arguing what the circumstances of the letters were. He's arguing you have to acquit this defendant.
Okay.
That's inserting, in our view, a personal comment on the evidence when it was not necessary, it was intentional. That's our position. Now,
Let me understand procedurally what happened. And this
Right.
comment, now folks, if you for a minute believe the state, you have to acquit the defendant if you believe the letters are contrived. That argument was made, rebuttal was finished, the jury commences deliberations, and then there was a motion for a mistrial based on the statement. Is that what occurred?
I think that's accurate, Judge. I would have made it differently, but defense counsel made the motion for mistrial at the point that you suggest.
And then a subsequent hearing was heard pretty much
Yes.
spontaneous with the motion for mistrial. And
Exactly.
Judge Parrish's findings were made on the record at that time.
Exactly. And then it was, of course, used as the basis for a new trial. But the point is that she did object by filing the mistrial. I would have filed it or made the objection on the record at a different point, but that was her
Do
choice.
you disagree with the statement? If you believe somehow the state somehow contrived letter, you have to acquit the defendant. Isn't that favorable to your client?
Well, I don't think so.
If they for a moment believe that, you have to. That's something that would be in favor of your client, wouldn't it be?
Not exactly. I think because it wasn't, that's not what he meant. According to the objection and to the language that was used by defense counsel, his facial gestures, I don't know that you can take this any other way than a sarcastic remark. And it wasn't meant as, well, you need to acquit. There's no prosecutor who really believed that after an arduous trial, all kinds of evidence coming in, hard work on both sides.
Mr. Wells,
What?
is
Yes,
it
Judge.
a violation of any law or rule we've set out to be somewhat sarcastic?
Well, it's not a rule. I think it's inappropriate, certainly.
Is it prosecutorial misconduct? Have we ever said that?
I think it
we've-
is,
I think
yes.
we've said that prosecutors can be somewhat colorful, and haven't we?
I was colorful myself at one point, but in other words, I think to insert that kind of personal comment in an obviously sarcastic way that was not meant by the prosecutor. There's no way you can say that's what he meant. You go acquit this person. That's just just wasn't what he meant under
Counsel,
the circumstances.
assuming we agree with your position, how does this harm your client and to what extent?
Well, it harms because it was pivotal evidence. If you look at the evidence in this case,
Weren't there some eyewitnesses who testified, yes, your client was there at this scene when this woman was shot and killed?
right, there was evidence to that effect from some debatable witnesses that were in turn either defendants or they cut a deal with the state. But I think what's important is that this, out of his own words, Mr. Netherland's own words, this was the one direct connection. These letters were the one direct connection.
Well, this is felony murder.
It is.
Okay, so what the state had to prove, they didn't have to prove that Mr. Netherland was the shooter. They had to prove that he was participating in the botched burglary, ag robbery, whatever it was, and that in the course of that, or in the commission of that, someone was killed.
That's exactly right.
And we have eyewitnesses that put him there participating in the botched ag robbery or burglary, correct?
Right.
And so why was it essential, why wasn't there evidence from which a rational jury could have convicted this defendant without the letters?
Oh, I think there was evidence. I'm going against my own position in issue one.
And so that if the prosecutor's saying if the letters don't fit, you must acquit, that really wasn't the case. And that was really beneficial to your client because there was evidence from which they could have convicted him, even if they thought the letters were not credible. Was there not?
Yes, there was evidence, obviously. But again, the context of it, the facial gestures, we can't record that, obviously, but there's no other way to say it other than that's not exactly what he meant, or it's not what he meant. He really, I can't imagine that this prosecutor really wanted this jury to acquit this defendant. This is a horrible crime. And I think it's reading too much into that, frankly, that was the message that he made.
Mr. Wells, are you abandoning your first issue on sufficiency?
No, I'm just arguing issue 2 first
Okay.
because I think it was more significant. In fact, I am not abandoning it at all, but I will stand on the brief. I took great pains to be as thorough as I could on the facts and the argument, and unless the court has some questions about that argument, we would stand on the brief.
I just wanted to make sure I understood your position today. Thank you.
Not abandoning it at all.
Just so I'm clear, back on the second issue, it's your position that the prosecutor's comment was so flagrant and abusive and egregious that
Yes.
that would be a basis for reversing these convictions and
Yes.
remanding for a new trial.
Yes.
Thank you. Any further questions? Thank you, counsel.
May it please the court, the state appears by Assistant District Attorney Jody Litfin. I'll jump right in with the prosecutorial misconduct issue. It's the state's position here that the prosecutor did not make a comment that was outside of the wide latitude. So on either prong, we would argue that it doesn't go outside of the wide latitude that's afforded to prosecutors here, or even if the court finds that it is, that it's not reversible error.
Was it true? He said if they found the letters were contrived that they have to acquit. Why wasn't there other evidence from which they could have convicted without, even if the letters were incredible?
I think that there was other evidence, and I don't think that was true. The way that I kind of read it was, since it was in rebuttal closing, is that he was basically restating what defense counsel had argued for 4+ pages in the transcript of attacking these letters, a lot of attack on these letters, and then he sums it up with, I think he's just restating her argument. Well, if you don't find the letters are credible, then you have to acquit. And then immediately jumps into, what are the evidence that we have about these letters? Here I'm going to show you why they're credible and what the evidence shows about the letters and why that argument holds no weight. And I think that we have to look at it in context also. We can't just look at that one isolated statement and ignore all of the prosecutor statements after that talk about how the evidence came in regarding the letters. But yes, I think the jury could completely disregard all of the evidence about the letters, and there was still overwhelming evidence to convict him on the felony murder.
Well, doesn't that give one pause for the prosecutor to tell the jury that it can reach a verdict that may be contrary to the evidence, the other evidence? I mean, this isn't true. If they believed for a minute that the state contrived, but they believed all the other evidence, that he was there, that he had a gun, that he was involved in the burglary, the ag robbery, and that a person was shot and killed, the letters that's just corroboration, right?
Correct.
And so, doesn't it give one pause at the prosecutors saying acquit the person even though there's credible evidence to convict?
Yes, but I don't think that was his argument in saying, his argument was not, if you don't find the letters were not contrived, you have to convict. It wasn't, it doesn't live or die on these letters. I think he can make that argument as a restatement of what defense counsel had just hounded to the jury and really attacked to the jury, that we got to look at what the evidence is about these letters. So I don't think so.
Ms. Litvin, I think you were in the courtroom for our earlier argument this morning dealing with prosecutorial misconduct, right?
Yes.
I'd like to hear from you on the questions I was asking Ben about the difference between potential difference between error and misconduct, and what qualifies as what, and what factors we should consider. I just want to give you a shot since you're here.
Well, I would agree that I think there is some distinction to be made between misconduct and error. And it kind of took me as a surprise. I didn't know if this court was ever going to address the difference between those, and I don't think that I personally raised that in our briefs, but we would agree with the rest of the state and that there's a distinction. And I think specifically in the context of misconduct in closing argument, I think misconduct is a broad term that can be used, and maybe I associate that more with other things that a prosecutor could do, like intentionally withholding evidence, or things of like an extreme nature, not having to do with comments in closing argument. So I think that error is especially appropriate when we're talking about comments in closing argument, and as in our case, rebuttal closing argument when it's a reaction to maybe some of the defense counsel's comments and something that's not put in your outline, as you talked about earlier. I agree with all of the factors that were listed. I don't know that I have any to add other than to focus really on repeated.
Excuse me. Do you have any case to point to on whether sarcasm is prosecutorial error or misconduct?
I don't think I cited to any or
Okay.
in my brief, but I do agree that there is some latitude regarding a prosecutor's argument. But
For a little bit of literary embellishment.
yes, but I don't think there's a case that says sarcasm equals misconduct.
Okay, I was not aware of one, so if you were, I wanted to make sure to get that too. What about unprofessional conduct? Is that something that should be addressed at all under either error or misconduct?
Specifically during closing argument?
Just kind of unprofessional behavior. Does that have any role at all when we're looking at those cases?
Maybe more towards misconduct.
Okay.
All right, thanks.
It's so fact. I mean, I think I'd have to know what it was.
What it
maybe.
was.
Yeah.
Fact intensive. Okay.
Yes. But I don't want to say that it shouldn't be considered, because I think that might lean more towards if something's just error as opposed to misconduct. Yeah.
Okay.
We're
thanks.
probably being a little unfair throwing this at you that's not for your case, but I'll continue in that theme. And
right.
You indicated that like withholding evidence would be an example of prosecutorial misconduct, which rightfully so. But how would you compare that to stating matters not in evidence or misstating the law? Do those are they comparable? especially when we're talking about in the first part, not the non-rebuttal part of the argument.
I think it would be more egregious, certainly, to do something withholding evidence, or I just threw that off the top of my head, something else that's at a different stage in the case, maybe. But I think the closest related one to that would be a misstatement of a longstanding rule of law, and it would have to be, I think it would still be less and fall maybe more on the error side than misconduct, but I can see how they would be closely related. I think a misstatement in the evidence or a fact misstatement is an error that I don't believe would go more to the misconduct side, and it could just be a slip of the tongue, even if it was in your initial closing argument. Because if we look, maybe use this as an example, at the prosecutor's statement here, even the next day, the prosecutor, I don't think, realized that he said if the state contrived those letters and had to look back at the record. So I think it's very easy to forget what was said in a closing argument very soon after and then have to go back and look at it. So I think that even in your initial closing argument or rebuttal, it goes very quickly and things aren't remembered in the exact way that it happened. And then,
Counsel, I might go back to the question that was asked in an earlier case. Why should the court care whether an error is just error or whether it's misconduct on the part of the prosecutor?
well, I agree with what the court was saying as far as disciplinary conduct. And I think that it does, it's like a tarnish mark on your, I wouldn't want to be associated with misconduct. I think that connotation is so broad, like I was saying, it's much worse than error. And an error could be an inadvertent error. It could be, it's not as egregious, I would say, as the term of misconduct.
Well, putting aside what I'd call your code of integrity, and I understand that's very important to lawyers, but what difference does that make to this court when we're trying to evaluate how severe the error is and what we should do about it?
Well, I think misconduct would maybe go to more conduct that was intentionally done and not, like I said, inadvertent or a mistake. And so since we're held to a very high level, prosecutors are specifically even more than other lawyers, maybe that would cut against our high standard if it was just an inadvertent error as opposed to misconduct. If that makes sense.
And to go again to a question that was asked earlier in a prior case, is it possible in your view that regardless of how strong the evidence of guilt of the defendant is, that because of what the prosecutor did or failed to do, usually what the prosecutor did, that the case should be remanded for prosecutorial error or misconduct?
I hesitate to say yes, but I think that there could be a case where it would have to be really ridiculous and egregious. I think that the prosecutor would have to go against multiple longstanding rules of law, orders by the court. I believe this defendant's guilty. You should too. The victims are truthful. Going through any evidence that the court told, the prosecutor not to talk about. I mean, I think it would have to be seriously egregious and hit on multiple issues. But I think there could be a circumstance where it would outweigh all the evidence. But in the majority of the cases, I would say no. But I think there could possibly be a time that it was so bad that it would.
Well, thank you.
And you say that because you believe that those multiple instances and the seriousness of them would show an intent by the prosecutor?
I think it would, support that it was intentionally done, especially if you had something that was done in direct opposition to what the court had ordered, and it wasn't just a misstatement of fact or I think even one misstatement of law is not enough. I think it would have to be several errors, not commenting on the evidence at all, just a perfect storm, I guess.
Would you equate that with ill will?
Yes, Your Honor. I mean, I think...
So your focus is on penalizing the misbehaving or misconducting prosecutor when you're looking at whether it should be overturned versus the due process. Everyone has a right to a fair trial. Even guilty people have a right to a fair trial. And it would seem to me at some point the misconduct would get to the point where the fairness of the trial is constitutionally unacceptable, or the unfairness is constitutionally, rather than penalizing the prosecutor, because we have disciplinary administrators to do that, right?
Right.
And so would you agree there comes a point at which the trial is so unfair that it cannot be excused because of overwhelming evidence?
I think that there could be a point. Like I said, I don't know what the perfect storm of that would be, but I think that there could be a point. And yes, I agree that it should be something to where you can decide that the defendant has been denied his right to a fair trial. And I don't think it should be about the punishment of the prosecutor if it came across that way. I think that the term misconduct can associate itself with a negative connotation for the prosecutor, but yeah. Because I think it would take a lot to get over if you had overwhelming evidence, someone confessing and whatnot to get over that.
So your primary consideration would be it's a due process violation if the conduct is egregious enough, and a secondary consideration is to punish the prosecutor. Is that what you're saying?
I don't know if I want to say that the punishment of the prosecutor should be considered in those terms, but I'm saying if we couch it as misconduct versus error, I think that's a consideration for the distinction of those two terms, and that misconduct can lead itself to further consequences rather than error.
More misconduct has a flavor of intentionality and
Yes.
maliciousness.
There is an aspect of that when we go to reversibility, but I still don't think, I think you could call it, was there prosecutorial error, and was that error reversible? I don't think I think we could take misconduct out of it for.
Of course, if we reformulate the test for error and misconduct, we might also reformulate harmlessness.
That's true.
That's an issue for another day. Thank you.
You're welcome. Also, one thing I think that's interesting in this case, dealing with the error, is that we had the district court, we had this motion for mistrial, which, of course, our position is that because they didn't object at the time, that would lend support for our argument that the comment really wasn't improper, and the state realizes that you don't have to object. But defense counsel here did make several objections to comments that were made and did not object to this one, although upon reflection and sleeping on it, the motion for mistrial was filed. But what's important there, I think, is the factual findings that were made by the district court. So I think that takes away all of the arguments for, oh, his facial expressions, it was sarcastic. He clearly didn't mean this. He was being over-the-top sarcastic. I think the district court clearly determined that the tone was not inappropriate, the demeanor was not inappropriate, and this court should heavily rely on that in their determination that this was a proper comment and for the first prong of the misconduct. I can hit on the reversibility factors as well. If this court determines that the comment was outside of the wide latitude, our position, of course, is that it was not gross and flagrant. This was one comment that was made during rebuttal closing, not repeated, emphasized, or there's no evidence that the prosecutor specifically made these comments because he knew they were inappropriate. There was absolutely no evidence of ill will here, and as I go into my first issue, our position is that there was overwhelming evidence here. And I can just submit the other sufficiency issue, but I would like to point out that the state did provide direct evidence that Netherland was the shooter, so we believe that we did provide sufficient evidence here for the felony murder charge.
Of course, the evidence that he was a shooter is not required for that charge, correct?
Correct, and I think that's what even helps the state's position even more, is that we provided evidence that wasn't even necessary, but very strong evidence that he was the actual shooter.
Very good. Any further questions? Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
Chief Justice, I'll waive my 3 minutes rebuttal.
Okay. Counsel just stated off camera that he's waiving rebuttal. Any questions? All right, thank you. We thank both of you for your arguments this morning. Court will take this matter under advisement.